We're going to talk about what is probate, and we're going to unmask the hidden threat to your estate. I will tell you, probate is something you should take very seriously if you're concerned about the peaceful transfer of wealth from one generation to the next. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have 30 years of experience as a lawyer. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, a real estate broker, securities and insurance licensed, and a pilot single engine land instrument rated, not current. And these are the attorneys in our firm. We are dedicated to all things peaceful transfer of wealth from one generation to the next, while minimizing taxes and protecting the inheritance for your loved ones from creditors, predators, and divorce. You know, the future ex-son-in-law and future ex-daughter-in-law, we're very, very mindful of that. This is a disclaimer. It's very important. When I use the term you, there's no attorney-client relationship. Please don't watch this video and just go out and do a bunch of stuff on your own, you know, because I said so. It's a bad idea. You should have some competent, savvy legal counsel. So why should a person understand the probate process? Because if you don't have an estate plan, your estate will likely go through probate when you die. And if you don't have an estate plan and you own a home and a bank account or even just a car in your name, you're in the game. Your estate's going to go through probate. You're typically facing this probate process, and probate's a little bit like quicksand. If you don't know where it is, you're going to stumble right into it. And if you don't know, if you do know, you can build a bridge over it, right? And that's exactly what smart estate planning does. Is we know it's out there. We know everyone. We are born and we die. That is the fundamental human experience. After we pass away, our stuff stays here, and that stuff has to go somewhere. It's going to go to your loved ones. It's going to go to maybe your future ex-son-in-law or future ex-daughter-in-law if it's not planned properly. It might escheat to the state, meaning pass to the state of California. They've got enough of your assets. I don't think anyone wants that. But without proper planning, all of these are possible outcomes. So avoiding probate is typically the smarter move. So if you've heard about probate and you're not quite sure and you want to plan your estate, and maybe you're looking at a will versus a trust, please understand that a will does not avoid probate. A will is a one-way ticket to probate court. A living trust in California is the way to avoid probate. So let's talk about what is probate. The legal definition of probate, and this is right off the Placer County Superior Court glossary. So in doing research for this, California has 58 counties and they all typically have their own website. And this is not a helpful definition, let me tell you. Probate is the judicial process in which an instrument purporting to be the will, like, what does that mean? All right. The judicial process in which an instrument purporting to be the will of a deceased person is proven to be genuine or not. Lawful distribution of the decedent's estate. An instrument purporting to be the will. This is very important to understand. A living trust is a valid binding document the moment it is signed. When somebody creates a will, that is a valid legal binding document only after two things happen. The person writing the document dies. Secondly, the probate court accepts this as the decedent's last and true will. So their last will and testament. So you might have done a will 10 years ago, then 5 years ago, and then a year ago, and then you die, right? The last will you did, and that's why we call it last will and testament. The last one in time is the one that holds up, right? Most wills say, I revoke all prior wills and codicils, and a codicil is an amendment to your will. But it's very important. If you're facing probate, if you have this will, having this will does not avoid probate. You're going to have to go through that process. And really, that's why the banker or the realtor might have told you, you need to go through probate in order to get your name on the deed or your name on the account to deal with the property. So they continue with the probate definition as the legal process of administering a will. What the heck does that mean? The legal process of what is administering a will? Well, administering a will includes the judicially supervised process for marshaling. Now that's a new word. For marshaling a decedent's assets, paying proper debts, and distributing the remaining assets to the persons or entities entitled to them. An estate may be probated even if there is no will. So in the absence of a will, this is what we talked about earlier, intestacy. In the absence of a will, those assets pass pursuant to the laws of intestate succession. So California, if you die a California resident, they have intestate succession. If you die a Texas resident, Texas has its own laws. So it's very important if you move from one state to another, the laws are different. Now, they're similar, but they're not the same. And it can be very complicated. If you're living in California, then move to Texas, but you own real estate in California, now you're a resident of Texas, and you die, what law controls? That's a very interesting question, right? And so I'm not going to use the lawyerly answer of it depends, but each state is going to have a say on who inherits what. So it's very, very important to understand that where your domicile is becomes much more important. A living trust kind of resolves a lot of these issues, quite frankly, in a way that a will doesn't. So I don't want to get too in the weeds on this, but marshaling is very important because we also marshal assets in a trust administration. So after somebody passes away with a trust, there's a similar process of organizing or collecting all of the assets, hence the English word marshaling. So the legal definition of probate, as explained by an attorney, this would be me, probate is the court-supervised process of proving a will, meaning the judge saying, yes, this is the decedent's, which is the dead person, the decedent's last will and testament, if there is one, or deciding who gets the assets, where they go to if there is no will, and that's the intestate succession. So it's ultimately the probate judge who ratifies all of this. Now, I have heard a probate judge say that a will is merely a wish list for a probate judge. And I've seen a probate judge years and years ago, the will called for the euthanization of this decedent's 10 dogs. Now, if you can believe this, this is a horrible thing. The judge asked the executor, and I was there in court. This is when people used to go to court in person and not on Zoom. And the judge asked the executor, how many dogs have you put down? I put down 5 dogs. We've got 5 more to go. The judge stopped. He says, I'm ordering you as executor not to euthanize those 5 dogs. And why don't you bring them to the court? And then they had those 5 dogs were adopted by court staff later, which is, it's great. If you're a dog lover, great result. But I want to mention that because just because your will says to do something, a judge can say, well, I don't like what you're doing and I'm not going to let it happen. And there's really there's no appeals process, meaningful appeals process in a case like that, because that discretion is often exercised by the trial level or judge on the bench in the matter. So just something to understand. The reason I tell you that story about euthanizing the dogs is to know that a living trust does not get that kind of a treatment. A will does get that treatment where the judge says, I don't like this term, right? And because the judge has to affirmatively ratify the terms of the trust, whereas ratify the terms of the will and say that the will is the valid last will and testament. On a trust, the court does not have that type of authority. So when does probate happen? If there's a will, the will gets filed with the court after death, not before death. If the person has not died, the court's not going to accept the will. The court goes through its process to ensure the validity of the will. Debts are paid before assets are distributed. I cannot stress this enough. A lot of times people say, well, once I open probate, can't I just write the checks to the people? No, you've got to hold that money back. You can only distribute that money after a court order in the state of California. Other states are different, okay? Other states have not as much judicial supervision. California, heavy judicial supervision. Again, I know I've said this already, but a will absolutely does not avoid probate. Now, if there's no will, this is what we talked about, intestate succession. The court follows California state law to decide who gets what. This can mean distant relatives inherit rather than the people you actually want. Maybe your friends, maybe your your partner, the person you've been living with, who you've created a life with. Maybe your stepkids. Maybe you have a partner and you don't have kids, and your partner has 2 kids, and you really want your estate to go to those 2 kids that you kind of feel are your kids. You have to do an estate plan, folks. You have to do a valid will or trust. Preferably the trust. The messier the family, the riskier things become. If you're a blended family, if you're 2 spouses and each of you has children and one dies and the other inherits, right, as spouses, let's say it's all community property and the one spouse inherits, and then that surviving spouse dies, that property is going to that surviving spouse's children, not the children of the first spouse to die, right? So in a Brady bunch, if Mike Brady dies, Mrs. Brady doesn't do a will. She inherits everything from Mike. It's going to her 3 daughters. It's not going to any of his 3 sons. So very, very important. If you have a blended family, please pay close attention to this. So what does a California probate process look like? Well, in California probate process says, this is what the law says, Person dies within 30 days, the will must be lodged with the court. What does that mean? That means the original will must be tendered or given to the clerk of the superior court in the county of the decedent's residence. So if a person is a resident of Los Angeles County, you've got to give that to the clerk of the court. So the lawful requirement, the original will. If the decedent died a resident of Kern County, it goes to the Kern County Superior Court. The original will has to be lodged, and the named executor needs a copy. So there's liability if this isn't done. If you don't do this timely, you may lose your position if you're the named executor, right? So 30 days is not a long period of time. Start gathering asset titles, debts, and death certificates. So you want to start marshaling the assets, right? Figuring out where they are. Now, you might not be able to yet get your name on those, but you need to identify them. You need to kind of figure out, get the lay of the land on who the creditors are, and talk to a probate attorney. This getting legal guidance is crucial, I would say, within the first 30 days. So you say, well, gee, the person passed away, and then at 2 weeks of the memorial service, well, the clock starts ticking from the date of death. So pay attention to this. If this is you, if you've lost somebody, this could be a very difficult time for you, and I get it. So the second step is opening the case. You file your petition for probate. You publish the petition in a local newspaper, and service, meaning a copy of the petition, is sent to the people who are entitled to it, and that's all laid out in the California Probate Code. This is a petition for probate, DE as in decedent's estate, 111, and choose full or limited authority. Most people are going to choose full authority under the Independent Administration of Estates Act. Limited authority, if you don't have real estate or you lack a surety bond. Basically, a will can say that I nominate Joe as executor and do not require a bond to be posted. If the will does not waive bond, a court is going to say, well, look, you need to be bonded. And what is a bond? Well, a bond is if Joe runs off with the money, the bonding company replaces that money. It's not insurance, but the bonding company replaces that money in the probate estate. Basically, Joe has to have really good credit. If Joe has bad credit, he's not bondable, or it may be a very expensive bond. And typically the bonds are a couple $1,000. So most people, when they write a will, they waive bond. That's what most people do. Generally, it's full authority, much more flexible. You can have broader authority as an executor, get more done quicker, but an attorney can help you to determine which one is appropriate in your case. I would say 95% of the time it's full authority. Then you have the hearing. So the hearing has to be, by law, the hearing has to be within the 45 and 60 days of the date you file your petition for probate. Some courts are still under a significant backlog from COVID, if you can believe it, from 5 years ago. And, you're not getting that hearing within 60 days, even though the statute says it has to be heard within 60 days. At the hearing, the judge says, if everything goes right, the court appoints a personal representative, executor, administrator with will annexed. So it's an executor if there's a will, it's an administrator if there's no will. Still a personal representative, still the same process. But the reason lawyers and judges use these two terms is if somebody says they're the administrator of the estate, we know that person, that there is no will. If it's executor, we know that there is a will. Having an attorney with you, super, super helpful. I really wouldn't do this alone. Can you? Yeah. It's like, can you build your own plane? Yeah, that's home built. My dad had a home built plane that he didn't build, somebody else built. But he thought it's better if someone else builds it. Really, this is something you want help with because if you crash and burn, it can be pretty devastating when it comes to probate. Probate bonds are required unless waived by the will or by all beneficiaries in writing. If a person cannot qualify for a bond because they have bad credit, they're probably not the best person to be executor, but that's just a little bit of a sidebar. Again, the probate bond's a court-required financial guarantee, similar to an insurance policy, but not an insurance in the sense that if someone steals the money's replaced, that bonding company is going to send a bondsman to get the money back from the person who stole it. And the bond's value is based on the total value of the estate's assets and adjusted for the credit score, frankly, of the person serving as executor. And the fiduciary pays it, but is reimbursed by the estate. So ultimately, the estate pays it. Then you receive an order for probate. That's DE, Decedent's Estate Form 140, and letters DE 150. And the clerk of the court stamps the letters. You want to make sure and get the purple stamp, not the black one. The purple one is the original. black stamps a copy, and you're going to want multiple copies of the letters. You probably want one certified copy of the order. Sometimes if you go to sell real estate, they're going to need both. And this is something you get at the clerk's window. You're not going to get from the bench, from the judge. Sometimes it can take 4 weeks to get these after your hearing. Just depends on what court you're in. It's a very long, tedious process. Day-to-day setup. So you open a bank account, you're going to get an EIN, an employer identification number or taxpayer identification number. That is the form SS4 that's filed with the federal government. That is the that's basically like the social security number for the estate. You do not use the decedent's social security number anymore once they passed away, but you get this new employer identification number, and then various notices that have to be sent out. If you're selling real estate or doing other things in the estate, sometimes there are additional notices. I would say consider opening an estate bank account. So this is where you take your letters that appoint you as executor, and you take or administrator, you take those to the bank with your EIN number, and then they open an estate account, and then you can deposit checks made out to the decedent. Right. So if Jim Cunningham dies and Lori Cunningham is the executor of Jim's estate, the check made out to me can be deposited into the estate account for Jim Cunningham, even though Lori's name is on there. You send out notice of administration to creditors. This is DE 157. This is critical, absolute black letter law requirement. Creditors must be notified. All known or reasonably ascertainable creditors are entitled under the California Probate Code to a notice from the executor, or the attorney sends it out, but we notify all the creditors. Jim died, Lori's the executor. You have 4 months to make a creditor claim. They make a creditor claim, you can either accept it or reject it. If that claim is made 4 months and a day later, you do not have the authority to pay that claim. I've seen a probate judge scold an executor for paying a late claim. He says, you do not have the authority to pay that late claim, right? Even though they wanted to pay it. Maybe it was to a family member, whatever it was. But there's a 4 month, as we say, drop dead, no pun intended, a drop dead date on filing those claims. That expires 4 months after the date of letters or 60 days after the notice. So if you go, well, I'm just not going to notice the creditors, they're entitled to notice. If you don't notice them, you have to later tell the judge under penalty of perjury. I have sent I've sent all notices to known or reasonably ascertainable creditors, and that's just fraud. And that, is that criminal? Maybe, but you really have to be truthful. This is very important. So in terms of marshaling the assets and marshaling the identity of the debts, this is an official, it's like you're an agent of the court. So like a marshal is the agent of the monarch or president. If they're leading an army, you're in charge. If you're the executor, it's on you to make sure that you do it properly, and you have to do it correctly. Otherwise, you're going to be held personally accountable. So you got to follow the rules. Within 90 days of the issuance of letters, some government agencies in California are entitled to notice. Medi-Cal or Department of Healthcare Services, Victim Compensation Board. This is if the decedent had committed a crime and was owing restitution, which does happen. Franchise Tax Board, right? If you got to get the clearance from Franchise Tax Board to make sure you paid all your California taxes. Inventory and appraisal, you have to file your inventory and appraisal. This is from Decedent's Estate Form 160 or DE 161 within 4 months of the issuance of letters. A probate referee, which is appointed, the probate referees are administered through the state controller's office, appointed by the governor. And that probate referee is appointed by the court on the order for probate. So if you gee, I don't know which probate referee do I contact, that box should be checked, and that name is stamped typically on the court order. That's the probate referee you want to go to. When you file the inventory and appraisal, you must also file certified compliance with Revenue and Taxation Code Section 480. This has to do with California real property and changes in ownership. If you have an LLC, so if somebody dies with no will with an LLC that owns real property, you have to notify the Board of Equalizations. Counties often don't expect, you have to notify the county of a change. So if the property's in an LLC, you notify the Board of Equalization. If the property's in a decedent's name or a living trust, you're going to notify the county assessor's office, and you got 150 days to do that. But typically you're going to want to get on that pretty quick. A change in ownership. This is very, very important. A change in ownership of real property likely will have massive tax consequences. You need to speak with an attorney before filing this. Please speak with a lawyer because there are other time limitations. So a lot of people want to inherit the parent's home and not pay and save basically $10,000 a year on property tax. There's some forms that you have to file. So you want to engage with that lawyer early on. And there are really some drop dead time limits on here. So if you're inheriting a home, there is this process where you have to notify the assessor that mom or dad have died in the example of mom or dad, and then they're going to reassess the property. So you need to bear in mind that that's another expense of the estate. So let's look at an example here. Jane purchases a home in LA County, Los Angeles for $120,000 in 1985. Jane keeps the property for 40 years. Well, what has it done? It's gone up in value. And she passes away in 2025, so 40 years later, and leaves it to Kevin, her son. The fair market value, it's gone up 10x. It's worth $1.2 million, but the assessed value is $263,000. How does that happen? That's because the assessed value was $120 in 1985. That assessed value only goes up 2% a year every year. So the property taxes, maybe 1.25%, or about $3,300 a year. If it's reassessed when Kevin inherits it, the son, the taxes jump to $15,000 a year. That, folks, is a big, big difference. Sometimes Prop 19 can help Kevin keep the low property taxes. So it's something where you want to talk to a lawyer because who wouldn't want to save $12,000 a year? I mean, it's a no-brainer, right? Step 6, consider selling real estate. If you have full authority under the Independent Administration of Estates Act, that allows you to sell real estate without a separate court confirmation hearing. Still subject to notice. There's still stuff you have to do. Limited authority usually requires court confirmation. And just think about that. You're trying to sell this piece of real estate. You have a buyer, and now you got to go to court confirmation. I mean, nobody wants to deal with that. You're much better off with full authority. Before major moves like selling homes, like selling the house, you have to give a notice of proposed action. That's Form DE 165. The beneficiaries have 15 days to object. A lot of times we'll just send a consent so that they're not objecting, after which you can proceed, or they can sign DE 166 to waive notice, right? So this is all the stuff that happens in selling. Doesn't this sound complicated? A living trust, significantly more complicated. You don't have all of these forms. You don't have the notice. You're the trustee. Much more informal. But probate is, and this is why probate's so expensive. So this is where structuring assets for distribution is critical. If you have real estate, it's actually better in some ways to sell it during the estate administration. There are too fewer warranties of title. If that property is distributed in individuals at the conclusion of probate, there are more warranties of title, and we're not really going to get into that. We cover that in other videos, but just understand on a high level, it's oftentimes better to sell that property during the estate administration. So number 7, handling creditors' claims and bills. Creditors, if they've been served a notice because they're a known or reasonably ascertainable creditor, or maybe they're not a known, maybe they're an unknown creditor, but they subscribe to a service that pings them that says, oh, this person died, that person died, and maybe they've got this database, which I'm sure is out there. The creditor files a creditor's claim, DE 172. The executor, administrator, you allow or reject each claim with a separate form, DE 174. These are filed with the court. Rejected creditors generally have 90 days to file a lawsuit. They can file a lawsuit and say, well, you know what? I think we're owed $10,000. And the executor says, I'm rejecting your claim. And they say, well, we're going to file a lawsuit. We want to get paid our $10,000. So it's very important. What if there isn't enough money to pay all the creditors? And if this is you, I'm sorry to hear this. There's a priority of payment. You have to keep immaculate records. You need legal advice on this because some creditors have priority over others. Last illness, funeral expense, burial expense have priority over others. The federal government has priority over everyone, even including the lawyer and the lawyer's attorney's fees. So if you end up dying with a big federal liability, if you took out an EIDL loan or a small business administration loan, death under many of those notes with the SBA and the EIDL loans, death is a default and all that money's due, and the federal government is a super creditor. So very important to understand. So why is probate so bad in California? Why is it so bad? It's time consuming. All the stuff we talk about realistically takes 16 to 24 months. The fees are 4 to 8%. Can be as high as 100%, and we'll show you why. Probate's a public process. All of those documents we talked about are it's publicly available information. Anyone can walk in and say, who's inheriting? How much are they inheriting? What date are they inheriting? How much did that house actually sell for? Which, you can probably get on other publicly available databases. All of this is public, and this is very creditor focused. Probate is all about paying creditors. A living trust is all about getting assets to your loved ones. So having only a will in place means probate court. A probate on $1 million estate, $23,000 to the executor or administrator, $23,000 to the lawyer. This is even if the house has a $950,000 mortgage, $50,000 in equity. By the time you sell the home and pay the realtor commissions and then pay these other fees, there's not going to be anything left. A $3 million estate pays $43,000 in attorney's fees and $43,000 to the executor. Now, these are the maximum allowed by statute. Most probate practitioners aren't going to do this for less than the maximum amount, because a lawyer's going to work for 2 years and then get paid. So think about that. Would you want to work for 2 years and then get paid? No, most people don't. And so that's why you will not see much discounting with lawyers. $10 million estate, $113,000 to the executor and $113,000 to the attorney. We have a probate fee calculator on our website. There's a link here on our YouTube page, and I would encourage you to take a look at that. So that's our probate fee calculator. And once you get over 25 million, it's a different calculation. We do see those. We see a lot of estates in the 5, 10 million, 1 million, 500,000, whatever it is, a whole range. But there are people that have very large estates that never get around to doing a valid will or trust. I mean, look at Prince, $150 million estate. So probate is, would you rather go across the Golden Gate Bridge or some really weird rope bridge from Indiana Jones movie? I think I would rather take the better bridge, right? So living trust, much better way to go. Probate, it's the rickety bridge, but with an attorney, they can help you through that. But simply much better to go through on the Golden Gate Bridge. Well, that brings us to the end of our time together. We do have office locations in Northern and Southern California. And if you're watching this on YouTube, please subscribe to our YouTube channel. If you have a question, you can put it on the notes section or comment section, or you can come to one of our webinars and ask questions live. But thanks for watching. Keep watching. Another video is going to roll up right after this one.